Yes, we are live. All right. Welcome to the latest episode of the Prima Law podcast. We are officially starting a new season because I didn't do some episodes for a couple months, got busy with other stuff, but I've had so much fun doing podcasts and videos recently. I said, let's do a good quality production and we'll have guests. And so today we have with us a good friend, Attorney Greg Vanderwood. Hi, Greg.
Hello.
All right. Let's make sure I've got the right graphics here too. So we are live. I see we've got 3 people watching. So for those of you watching, I'm Attorney James Betzel. I'm an immigration attorney. So is Attorney Greg Vanderwood. And he's with us today. And he's been working with us here at our office, helping take care of some consults and doing some work. He's been doing just a fantastic job. We're so happy to have him here with us. And there have been some pretty big changes in immigration law in the last week alone. And they've been like, not the depressing kind of changes that make you want to quit.
Yeah, we haven't had good news in a while.
Yeah, it's hard. It's kind of a foreign concept.
Yeah.
But it feels pretty good. I like it.
Oh, definitely.
So now that we have some good news, I figured this is actually a pretty good time to talk about it. And the 3 people who were watching just disappeared, but I'm sure other people will watch later. All right. While we're in this, let's do. There we go. There's the Prima Podcast logo I was looking for. Haven't used it in a while. So here we go. All right, Greg. The first thing I want to talk about is the U visa. First, just give us a quick background about the U visa and all the wonderful things that it can do for people.
Sure. So the U visa, it's a form of relief. It's a visa basically available to people that have been a victim of certain crimes here in the U.S. So it's a really great option for somebody who comes in and they don't have a family member, they don't have any other way of getting a green card, but they were a victim of a crime here in the U.S. And the purpose of the visa is basically to incentivize victims to cooperate with law enforcement in terms of going after the perpetrator. So that's basically in a nutshell what a U visa is. And up until, a few days ago, you had to wait a few years before you actually got your work permit based upon the U visa application. But there's been a slight shift. And so now you can get that work permit much sooner than you could before, which is great news for a lot of U visa applicants.
So back in about, were you practicing in 2014?
No, 2015.
2015. Okay. So in about 2014, I remember we had a number of clients who, can you turn your volume down a little bit? I'm getting an echo. Back in 2014, we had clients that we were filing U visas for.
Yeah.
And at the time they would say, oh, well, how long is it going to take to get my work permit? And we'd be like, no problem. It's like 6 months, maybe a year at the most.
Mm-hmm.
And for sure you got a work permit.
Yeah.
And you're good to go. And it was that way, but it was right around then when not only our office learned about U visas and how to file them and how to get them approved.
Right.
But I think dozens and dozens and dozens of other attorneys sort of started learning about that as well. And so there were a lot of applications for U visas being filed. There's only 10,000 of these visas available for the government to give out per year. And so there started to be a backlog. So instead of taking a year, now it was taking a year and a half. And it was 2 years. And it was like, we don't know when.
Right.
I'm actually pulling up right now the processing times, because the last I looked for U visas, not even a U visa, just a temporary decision on deferred action, and whether they would get a deferred action status and a work permit with that.
Mm-hmm.
It was 57.5 months on average. Wow. Let's see what it says right now. Oh yeah, it went up. This will be fun for arguing in the Sixth Circuit. Now it's at 59.5 to 60 months that somebody would have to wait in order to get the temporary benefits. And that's the time to the waiting list determination.
It's crazy.
It's not just you have to wait a long time until you get the visa. That right now is more like, well, I guess we can look that up too to find out exactly how many pending U visas there are. But last check is like 120,000. So 12 years, if you're filing today, you might be waiting until you get that final visa approval. As we're going along here, please, if any, I see we have a number of people watching. If you have any comments or questions, please throw those into the comment section. We can answer live from here on most of those platforms. So just go ahead and add a comment. We're going to try and stick to the theme that we're talking about today, which is the changes in immigration. So if there's any questions you have about any other recent changes, let us know. All right. So yeah, that was a huge problem. And the whole promise, like you said, the whole promise of the U visa was that if you come out of the woodwork, right? Even though you don't have papers, you don't have legal status, if you come out and you help the police put a criminal, bring a criminal to justice.
Yeah.
And it could be as little as just reporting the crime and then cooperating as much as needed, which might include actually showing up at court to testify. It might include testifying against a family member, a spouse, a boyfriend, girlfriend, whatever. And it could also mean, testifying against someone who is going to have a vendetta against you.
Oh, definitely.
And they might be in jail right now,
but they're going to get out soon.
They're going to get out. They're going to get out, and then they'll find you.
Yeah.
So the whole promise of the U visa was, in that situation, we don't want you to be vulnerable as a person, as an individual, or as an immigrant population either.
Right.
So stand in this line. We're going to give you a visa. We're going to give you a work permit in the meantime. But again, that like right now, 60 months. That's the published time. And then we're talking about this wait list determination, which is this temporary, deferred action for while you're waiting for the final approval. But that didn't always exist either. I'd have to look at my brief for the exact date, but I think it was in, I don't know if it was 2007 or 2011 when they created it, where, no, it wasn't 2007, it was after 11 or maybe 13 or 14, where they said, all right, we've got more than the 10,000 people applying. So there's too many people applying for U visas to be able to give everybody one right away. And so USCIS went through the regulatory process. What do you know about them? I feel like I'm talking too much. Maybe we could give people watching just a brief rundown of what that is.
In terms of, there's laws and there's regulations, and a lot of times Congress, there's a law that's passed, but it really doesn't spell everything out. And so some of that rulemaking authority is delegated to various executive agencies. So that could be the Department of Justice, the State Department, outside of an immigration context, the FDA. It's just an executive agency that's basically coming up with the rules or the implementation of what's going to happen. And there's certain procedures they have to take before they create these rules. There's a notice and comment period. So they have to publish their proposed rule, and they have to accept comments from the public regarding whether it's a good rule or not. And there's certain requirements for how long that is. And then, before that can actually become a rule.
So just talking about the regulatory process, when people make comments, do they listen? Like, they're the government, do they have to listen to the comments?
It depends on how cynical you are, but I don't know that they actually do. In theory, they would listen to the comments and they would, formulate or modify the rule based on that. Now, obviously, they're under no obligation to do so, but they at least have to accept the comments.
Yeah, and that's part of the process. And then when they come out with the final regulation, there's always like the regulation itself, which might be a couple paragraphs.
Yeah.
But then there's the comments and the justification, and all that's part of like the regulatory requirement that they have to fulfill.
Right.
So they have to say, well, we got this many comments. This many had to do with this many had to do with that. This many looked like they were just templates from this one organization.
Right.
And we've considered these things, and on this one, we decided this. And on this other comment, or this theme about comments, we recognize this, but have decided to do this instead. So occasionally, they do take it into consideration, and occasionally there will be changes made. I know that the American Immigration Lawyers Association, whenever there's a new proposed rule or something, they have a campaign for their members, which there's about 16 or 18,000 of them right now. And they'll say, hey, there's this new thing. Here's what we think.
Yeah.
What do you guys think? here's some templates. You should go to this link and put your comments out about it, because this thing is going to be huge, either good or bad or whatever. And one of the problems with immigration to begin with is it's an area of law with so many different applications, benefits, types of visas, types of laws, all that stuff. And it's all connected one way or another.
Right.
That's sort of the law of unintentional consequences.
Right.
Is a beast.
Yeah.
In this area of law. Anyways, so the regulatory process with the U visa earlier on, the government said, "Hey, we proposed this rule. You guys made some comments. Here's the three main options we figured that we had."
Mm-hmm.
Option number one was, when everybody files their application, we either just accept the first 10,000, because we can only give out 10,000 visas, or the first 10,000 that can be approved.
Right.
Everybody else will have to refile next year, sort of make it a seasonal thing, kind of like the H-1Bs.
Right. Yeah.
Where you either get it or you don't.
Right.
Try again. Well, one of the requirements is to get this law enforcement certification. There's a lot of stuff you got to do to build these things. So redoing it every year is not a very jolly prospect. And they recognize that would be harsh and unjust, especially to people who are victims of crime. So they said, option one, no. Here's option two. Option two is we take all the applications and we try and figure out which 10,000 are the most deserving of the visa, grant those, and everybody else can file next year. Do you see any problems with that?
Yeah,
as far as fairness goes, maybe
it's not fairness. It's just a rush to who can get it first.
But with the first option, but if they're trying to decide who deserves it more, how do you do that?
Yeah, I mean that's sort of hard. I mean, how do they deserve who? How do they decide who is more deserving? I don't know that I want them deciding that.
No, you would need a whole other process,
right,
of rules and whatnot. Like, okay, well, if somebody died, then it's 5 points, and if somebody didn't die, then it's like 2 points, and then it becomes arbitrary.
Well, and I think too, with this agency authority with rulemaking, there's Chevron deference, where the courts basically defer to the agencies. So the agencies, although they didn't enact the law, they oftentimes just end up having a lot of authority that's oftentimes hard to check if you're trying to challenge what they're doing in court.
You used a fun word, Chevron. Chevron, like the oil company?
Well, kind of, yeah. I mean, that's the case name. Brand X, I guess, is another one, but it's this deference where the courts will say, "Hey, we're just going to defer to whatever this agency decided, because they're the subject matter expert. We're just a court. We're not going to substitute our judgment."
Yeah. Do you remember there was a case about, maybe it was about like 6 months ago, and I don't remember the name of it, but it came out of the Supreme Court, and pretty much, I think it was like an 8-1 decision.
Yeah.
And the one was Samuel Alito, because the court was undoing was this an immigration one? I think it may have been an immigration related case.
Oh, okay.
Too. Might be fun to look up later. But anyways, the court was like, it wasn't Pereira. Was it Nis Chavez?
I think, Nis Chavez, I think, was a 9-0.
Yeah, no, so that wasn't it.
No.
But I think it may have had to do with immigration. Anyways, what the court, and the majority of the court said was, we know what Chevron deference is, but we can also read.
Right.
And the law is pretty darn clear on this point.
Yeah.
So I think it was the originally the plaintiff or the immigrant, if it was immigration, because I think it was. But essentially they said, this is what we're doing. Yeah. And then Samuel Alito in the minority said, or in the dissenting opinion said, are we just going to pretend like Chevron deference doesn't exist anymore? Right. Chevron deference is the law of the land, so we should defer to the agency. But all the rest of the Supreme Court justices were like, no, the statute says this, and that's what we're going to go with.
Well, I think one thing to note is that the BIA is part of the Justice Department. So that would be one of these executive agencies that's entitled to this deference. So, you have a Circuit Court of Appeals reviewing a BIA decision. They also owe essentially this lower court Chevron deference, which is sort of strange once you think about it. But it's an executive agency, but it's functioning as a court.
As a court, yeah. Well, and let's be honest. I mean, the BIA, they're pretty much the worst, right? I mean, when it comes to, I mean, let's look at the type of people who are appointed to the Board of Immigration Appeals. It's not federal judges. It's not typically not someone from the AUSA's office. So the Attorney General of the United States of America's office, where they work as like a public prosecutor for the federal government.
Right.
These people are ex-immigration judges who I believe, I gotta use my words carefully here. I believe there's one or two who were kept getting reported for bad behavior at the immigration court trial level.
Okay.
And so they were promoted to the Board of Immigration Appeals.
Yeah.
Of course, at the Board of Immigration Appeals, you don't typically have, I don't think you ever really have oral arguments. It's just all done by paperwork. So he doesn't have to deal with anyone in the public anymore.
Right.
So that person can stay out of trouble. Two people, however many there were. And, but there are people with a very slanted view on immigration to begin with. So a lot of the decisions that we see come out of the Board of Immigration Appeals end up later being overturned in the Federal Circuit Court of Appeals.
Right.
The various different circuits, because let's face it, the BIA, I'm sure, is overworked as well. I know that's a huge case.
Right.
It takes, it takes at least a year and a half to get a decision.
Oh, at least, yeah.
And then at least probably, and then if you appeal it, you would go to the Circuit Court of Appeals for your circuit, but they're overworked. So anything they can do to fast track a case to denial, to fast track the case, which usually means just denying it, they've been doing that. And especially when you're full of immigration judges who are pretty slanted against immigrants to begin with, just from either their own experience, either as an immigration judge or as an immigration attorney, not immigration, ICE counsel attorney.
As ICE attorney,
the immigration prosecutor.
Right, yeah.
Not fun. So, where do we get on that from? Chevron deference. Chevron Oil Company. You had defer to agency. We're talking about rulemaking. And typically the immigration agencies are the ones who deal with things on a daily basis. So if something ends up being disputed in court, typically the court will defer if it's a judgment call, right?
Right.
So I see how it could go both ways.
Right.
So we're going to go with the government.
Right.
That's usually how it ends.
Yeah.
But when we were talking about the rulemaking, immigration was saying there's option one, there's option two, which are both sort of, we'll take 10,000 and then everybody else refile. And then the third option they enumerated there was, they may have had a fourth option too, but we'll just say there's three.
Yeah.
The third one is the one that actually happened, where they said, we're going to create a waiting list. So everybody who applies, they say the first 10,000. So they're not trying to decide who's better. This is what the regulation says. This isn't how it actually worked out.
Right.
But the first 10,000 get decided. If there's some who don't get approved, then we bring in some more, and 10,000 will get approved. Everybody else goes on a waiting list. And in the words of the regulation, they said that those who don't get the visa right away and are on the waiting list will get a work permit or work authorization that will be good until the next fiscal year. So the language that they had was saying, no, it's going to be quick. You'll have it now and keep it till the next year. They were contemplating that there would never be a situation where you would have a backlog of more than 2 years or of more than 1 year, right? Of course, that's what happened right away.
Yeah.
So what they would do, I don't know if you had any of these cases, but we had some where we had a client who was in immigration court, and they had a pending U visa application.
Yep.
There was a waiting period. And if you look at the instructions and the memos that ICE has to follow, policy memos, they would say, hey, ICE attorneys, if you've got a respondent an immigrant in the court
Right.
who's got a U visa pending, you should contact the Vermont Service Center and ask for it's my favorite, it's where we got the name for one of my companies, prima facie determination. And then it says they should consider getting a prima facie determination. And which is just contacting the Vermont Service Center and then saying, yeah, the case looks like it's probably valid, yeah. And then for the person in court to do something to either delay the case or get an extension or administratively close it, which, that's another thing that came back. Was that this week too? That's probably last week.
Yeah, that was last week. I forgot about that one.
Yeah.
Yeah.
So they said, so that's what the memo said. Of course, for us, every time we asked for that prima facie determination, Vermont, well, we would call Vermont or communicate with Vermont, and they'd be like, no, only ICE counsel can do that. So we would call ICE counsel, and they would be unwilling to do that as well. And it wasn't like, oh, we don't know how to do it. It was, yeah, we're not going to do that. We got other stuff to do. So.
And you can't really force them, obviously.
No.
You just have to beg them.
At the end of every one of those little memos, it says, this memo doesn't create a substantive right for the respondent, blah, 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 because we don't want to have to do stuff we don't want to do. So there was that problem. That problem came up fairly frequently. In fact, we had one case where when we were, when I was representing him the first time in immigration court, we filed the U visa application. I remember I had him sign it. He was in jail still.
Oh, wow.
In the local jail. And we submitted it. And because immigration court cases can take multiple, 6, 7, 8 or more years, he actually got his final U visa approved before his final individual hearing date. So we were able to terminate his case and he had his visa and then things were fine. But that's the problem with having these huge delays in U visas is you got people stuck in other life situations.
Right.
Like maybe they're being in removal proceedings. Maybe they don't, or maybe they actually want to leave now so that a family member can adjust them or can petition for them, or the list goes on. And then combine that with the fact that they're already victims of crime and they, they're a vulnerable population. Making them wait like that's just insane. It was never the purpose of the statute. So that was the one they decided to go with. And then because there are people in those situations, what USCIS does is, they've got even a page about it on their website where it's like discretionary expediting of cases or something like that. Where if you contact them and you're like, hey, no, my client's in a real tight pickle. They really need this decided now. I know that it is in for another couple of years maybe, but please, oh, please do it this way. And I've seen clients come in and do consults with me and they show me their work permit.
Yeah.
And for some reason, within like 6 months of filing their U visa, they have a work permit already, which is unheard of in 2018.
Right.
But it's exactly what I was seeing with my eyes.
Yeah.
And so that's why when we're looking at, the processing times for a U visa, it says between 59 and a half and 60 months. There's a range in there. And that's on average too, right? So there's some people who skew that down, and then there's, I'm sure, people who skew that upwards as far as the average. So they were, in essence, picking the winners and losers, who was more sympathetic,
right,
instead of just doing the first 10,000. So there was no, and that's one thing that even, prosecutors or people defending USCIS in these federal court cases would say is, no, it's first in, first out. It's very strict. And that's a lie. It's inaccurate. Because there are those situations, and I've seen them. And I don't think they'd respond even to a FOIA request about that, because they would say, no, it's all private information.
Right. Yeah, they don't need to disclose it.
And they've had other people, former heads of USCIS, testify that, yeah, in fact, on occasion that does happen. But most of the time, it's first in, first out. That's what they said. So anyways, let's talk about what's new then. We talked about what's old. What's new with the work permit situation? We got a new acronym to deal with. Do you remember what it is?
I don't remember the exact words.
It is
but it's basically, was it bona fide?
Yeah.
I think that, yeah.
Bona fide? How do you pronounce it? I always say bona fide.
I say bona fide, but you say tomato, I say tomato, sort of thing. So
it makes me think of Bono from
Bono.
U2. Maybe we should call it bona fide. He's a cool guy, immigrant too. All right, so it's a BFD. And as soon as I posted about it on one of the immigration groups, somebody said, yeah, big effing deal.
Yeah.
That stands for bona fide determination. So in INA, there's a section 214P6. And it says that USCIS may provide work authorization to anyone with a pending bona fide application for a visa under this section, which is the U visa section. So in litigation, that's one thing that we've been pointing out over and over. So in these cases we've had here in the Western District, one out in California, one down in Ohio, we've been pointing out that they can do this. Like if we sue them about it, they have a way that they can do what the judge says. It wouldn't be illegal for them to just give us a work permit. And our argument has also been that it's already provided for in the law. There's no need to make any other regulations about it because it's very simple. The terms are easily defined. Because what's the one thing we know about bona fide? Even if we don't know what it means, we can probably guess what language it is. Latin, which is a dead language. So all the words have the same meaning now that they did thousands of years ago.
Right.
And bona fide or bona fide would be, made. I don't know the words exactly.
It would be good faith.
Yeah, essentially in good faith, right? That it's not without trying to deceive.
Right.
Not with any intent to deceive, but it's true and accurate and complete. So now. And what is funny because the government was arguing is they said, yeah, that's part of the law, but it says may, so we don't have to do it. And now we've decided not to do it under that section of law. That was always the defense in that argument.
Right.
And what we would say is, no, actually there's times where you do it. And they've denied it, but I think there's actually a good argument for that it actually exists, no other regulations necessary, and they should just do it. Right. And so what did they do? Well, we were right? Because when this change happened, it wasn't a regulatory change. There was no publication in the Code of Federal Regulations. There was no notice and comment period.
Right.
And it was simply a policy change that they enacted. And they specifically said, yeah, the law already says we can do it. And there's a section in their announcement about why they're doing this and everything that says Administrative Procedure Act concerns or justification, something like that.
Right.
Because that's the law that we've been suing them under. And they said, you know what? Under the Administrative Procedure Act, we also don't have to go through the regulatory process for this because it's just enacting something that's already provided for by statute. All the terms are defined. And a lot of the arguments that we've been making. So we finally got someone on our side over there somewhere, and in the Attorney General's office. And so, yeah, they enacted it without having to go through a regulatory process. We'll have to see if anybody thinks they're going to, if like Stephen Miller out there or something thinks they're going to sue the government about this now and try and stop immigration again. But I thought that was interesting to see that there so quickly. And what it means then, and they've got a flow chart and everything. It says if you file the application, essentially the application is complete. It's signed. You've included the written statement from the victim, which is a requirement in the instructions for the application. And the government has obviously received it. And right after they get it, they send you a notice to go get your fingerprints taken. So if they've got your fingerprints taken and the criminal background check has been done, then they can issue, or then they will issue a work permit. And what are there? There's like 120,000, let's say, pending U visa applications, right?
Right.
Have you ever seen a U visa? I've seen them where you file it and maybe something doesn't get included and they send you a RFE right away.
Yeah.
Or it gets rejected, right?
Right.
Hey, you didn't include a filing fee for a waiver or something like that, right? So What we know about that, and this is sort of something I worked through as I was preparing one of my briefs in a motion to dismiss in California, is they already have that step done. Is everything complete? Is it signed? Right now. Also, very typical that within maybe 6 weeks or so, they're getting that fingerprint notice to go get fingerprinted, right? So out of these 120,000 pending applications, they know which ones are complete. They know which ones have a clean criminal history, because that's what they do with the fingerprints.
Right.
The other thing actually that they said is we want to make sure they're not a national security danger, which they would be able to tell from the criminal history thing. And
Right, absolutely.
They do. So in that response to the motion that I filed, my point was, if they really wanted to, they could just issue the work permits, because they already know the criteria that they just laid out the other day for us.
Right. They have all the info.
They know which ones qualify for a work permit right now and which ones don't. And if you look a little closer in the instructions, they also say that, hey, by the way, we're not going to ask anyone to file another I-765 for this to get issued. They said, anything you have on file with us, we're going to count, whether it's under category, I don't remember if it was C14 or A20 or whatever, because there was a whole time where it's like, I felt like we were sending I-765 after I-765 to USCIS, because we would send it one way and the instructions said, yeah, file it under this category with the original application, and then later you can file a different one with this.
Yeah.
So it's like we were sending all sorts of them in, and we were still just waiting. Well, so now they said, look, anyone that filed, that's going to be good, and we'll just issue you a work permit based off of that one. So they're planning something. There's something in the works there. Otherwise, they wouldn't have said that. They would have said, all right, cut us a break, just send us some more filing fees, and we'll... Which is funny, right? Because for the longest time in litigation, the other thing they were saying is, look, we have limited resources. We're the government, but we're funded only by fees. We've got to cover these other areas.
Right.
And we just don't have enough money to hire people to decide all these things or to handle all these things. But what's the one thing they didn't do right now? They didn't ask for more money.
Yeah.
Everyone would have paid.
Unusual.
Everyone would have paid, for sure. It would have been morally reprehensible, right? Because they've already paid and they've already been waiting. I thought that was pretty neat. So yeah, so we don't have, and they didn't put any time frame in the announcement either. They didn't say it'll be done within 90 days of this or 60. They said anything that was filed before today or today or after is going to go through this process. So they're going to have this on a going forward basis. I would love to file another U-Visa like this week, just to find out,
see what happens.
Yeah, find out how quickly the whole thing would go. We could time it. All right, so if there's anybody out there who has a legitimate U-Visa that they would like to file, if you've already got the certification, contact us and let's see what we can do for you, because we would like to time this and know how that works. Oh, look at this. Okay, we got a comment. Greg. Here's a question for you. Hi, I have 2 questions, please. All right, we'll do question 1. Trying to check the status of U-Visa online, got error. They can't recognize the receipt number.
Yeah, so anything with a U-Visa, it's not going to show up online, and that's for privacy reasons. And the only way that you can get information is by contacting the Vermont Service Center, either you or your attorney, assuming that your attorney has filed a G-28. And again, that's to limit the exposure of this information. So if you have a receipt for a U-Visa, you look online, it's not going to show up because you can't get it online. It's only by calling the Vermont Service Center.
Yeah, and you have to be either the representative, and they'll check that, or the applicant themselves. So, and I think the second question we answered.
Right.
We don't know when they're going to start sending them.
Hopefully soon.
But from what they're saying, the way that they did this, it looks like soon. The other point of personal pride I had when reading that announcement was, they said, look, this is the history of the U-Visa, which is copy and pasted from the pleadings in federal court litigation done by Bradley Benias and other attorneys. So it was fun to see that little snippet there. But then it says, look, there's all these problems with the waiting period now. People are suffering. This is going on. That's going on. And this is like, additionally, USCIS has been subject to all sorts of litigation on this matter.
Right, right.
So it helped.
Yeah.
I think it helped. All right. So that's the good news on that. So U visas are going to go quicker. And I was just thinking at least from an attorney standpoint, from a business standpoint, there have been times when, a client comes in and they're like, well, I've got this U visa case. Should I do it? And if they have anything else, like a family petition or something that will go faster,
Right.
we say, no, forget that. Let's do the family petition instead. But have you checked processing times for like I-130 recently?
Yeah, they're taking pretty long.
I think I
So-
saw like 13 months or more.
Yeah, I mean, I think the calculus in terms of a U visa, it's probably going to change now. So maybe they're going to get a work permit quicker.
Yeah.
That way they can work while they're waiting, to actually receive their green card.
Yeah. And as long as they've got a legitimate U visa claim,
Right.
and with all of those, I know one problem I had with this Stephen Miller guy, he was this guy who was in a special advisor to
Mhm.
the former president, Donald Trump. He lost, by the way, lost big time. So he was a big loser in the last election. I just want to point that out. And he wears his pants funny. I saw that on the news. But
I think that was photoshopped.
no, it wasn't photoshopped. No way. That was for real. He's wearing a fanny pack under there or something.
Okay.
But Stephen Miller is this guy who was like his advisor on all things immigration.
Mhm.
And what experience did he have with immigration?
I'm not sure that he had
He
any.
didn't have any experience. He
Not
had
to my knowledge.
all he had was pundit experience, which means all he knew how to say was, well, we need to follow the law as it's written, even though the law is terrible.
Mhm.
And he was very instrumental in a lot of bad policies that were enacted, a lot of the things that are being reversed right now.
Mhm.
thankfully.
Mhm.
And I remember seeing him on the news one time, and he was talking about U visas, and the man knows nothing about U visas or how to apply for it or how to get one or why they're important or why they even exist, why Congress, right, a highly divided body for the last 50 years or more, probably since the founding, but they were able to come together on this one with the
Yeah.
president and say, yeah, we all agree there needs to be a U visa.
Mhm.
He had no context on that, and would say, "Oh well, they're just lying on applications and committing fraud." Well, the thing he doesn't know is that to file that application, you need a police certification. So, unless you're saying the police
Are somehow
lying,
in cahoots with this.
then you're not.
Right.
It's full of nonsense,
Yeah.
right? So there's really very little actual fraud that happens, at least from the immigrant standpoint, on these applications. And which is why in this notice again, they also said, hey, by the way, overall, 75% of these applications get approved. So way more often than not, they're approvable and they're legitimate.
Right, because really the hardest part sometimes is just getting that law enforcement certification, because you could have a client come to you and they're the victim of a crime, you contact the police and the police don't want to sign. And if that happens, that's the end of the road. But once you get past that step, again, it's pretty much guaranteed. You've already gone through that first step of showing that you helped law enforcement.
Yeah. So that brings us to an advanced question. Let's talk about law enforcement certification since we're on the U visa hitch for today. What if they don't want to sign? What if the police won't sign a certification, but the person was a victim of a crime? What are the options there?
So as far as I'm aware, law enforcement does have the discretion. So it is their discretion. And I don't know how you would challenge that by saying that the individual was not helpful if the police are saying they are not, because the police would be in the best position to say. So I think from a practical perspective, I at least personally don't know how you would compel them to certify it.
I know that not each, but a lot of police departments have sort of a policy,
Mhm.
written or unwritten, something that goes more or less like this. If it happened in the last X number of years,
Mhm.
we'll consider it.
Yeah.
We'll look and make sure that we're okay with it. And then there's Some police departments that go beyond that, some that go less than that. And when we've done that, at least with some of the local departments here, especially in Grand Rapids, they would, you submit your request in writing to like the police chief or one of the captains, and they'll pull a police report. So if your client is mouthing off and being, causing trouble and probably guilty of some of this stuff too, they'll say, we don't think so.
Yeah.
No. But if they truly were a victim, they would be pretty sympathetic to that. But it's police department by police department. But the police, well, and before I get to this other point, I think there are some things you can do. I had one case where the crime had occurred like literally 20 years prior.
Oh, wow.
And the department sort of had their policy of, we'll look at it in the last 5 to 10 years. But if it's longer than that, we won't look at it. And what I actually did is I was able to schedule the time because they had about 4 of these things that had been pending with the department for a while. So I was able to schedule a meeting with the captain who was in charge of signing these. And lucky for me, he was a busy man, but he kept his word and kept a meeting with me. And he came in and was like, essentially, all right. What do we have here? What's the first one? So I just gave him a 2-minute summary. There's this one, there's this thing. So put a couple of the easy ones first. And then sort of in the middle, I was like, this one's a little older, but it's very sympathetic because this and this and this. Good person, pillar of the community deal. And sure enough, went along and signed it, and super happy client right now. So I think there's techniques like that you can use when you can personalize it somehow. If you can get that FaceTime where otherwise it might not work. But again, the police aren't the only ones who can sign a law enforcement certification.
Right. So that's really, county by county, city by city. In some places, it's the prosecutor that can make that determination. It can also be the judge in some jurisdictions. But I think a lot of places, they delegate it to the police. But again, as you said, it doesn't have to be the police department.
Yeah. Immigration,
the prosecutor.
They say any law enforcement, which can be police, prosecutor's office, judge. Of course, if there was never a case or never a conviction, then that might be tricky. But there are those possibilities. So sometimes we've had where we submitted it to the police and they're like, no, we didn't like your client. So we submitted it to the judge and the judge was like, yeah, clearly a victim of domestic violence. And they signed off on it. And then there's some counties where the prosecutor's office will say, we defer to the sheriff's office. So it is then really up to the sheriff or to the judge. What about in the tricky? What about like a federal case? I don't know that
I haven't done any of those. Maybe the AUSA?
A certification from a federal agency or from a federal, the AUSA or a federal judge. If they go along with it, it would work.
Right.
What about, because they said it says law enforcement agency. What are some of the less typical law enforcement agencies out there?
National Park Service, Fish and Wildlife. I've never seen these cases, but that could happen,
Yeah, DNR probably, right? Well, DNR for sure. They're law enforcement in Michigan, the Department of Natural Resources.
Right.
So if you were a victim of a crime that had to do with with their jurisdiction and they handled the case, then you would go to them and could request that. That would probably be a first one for them.
And I think definitely. And I think sort of ironically,
somebody was trying to poach me.
Right. You could even have ICE or CBP sign your certification.
Yes, you can. The Department of Labor is charged with enforcing the laws regarding employment, and one of the qualifying crimes is, well, some of them I guess are like involuntary servitude, peonage, fraud in labor contracting, those things. So I haven't had myself, but I've seen cases or heard of cases where the Department of Labor will actually sign a certification. We had one that we requested out of Illinois. We wanted the state Department of Labor to sign one. They declined, but they could have. So it's not even always just the judge, prosecutor, or police department.
Right.
It could be one of these other agencies too.
Right. Right.
Obviously, the FBI is law enforcement. Obviously, DHS, like you said, CBP or ICE themselves. There have been cases where they have signed those off.
Right.
And I think I was sitting in an AILA conference one time, and they were doing like advanced U visa issues. Like, what could you do in this situation, right? Well, there's cases where immigrants are victims of legal violations by the police department, where whether they're profiled or they're in a situation like where the officer's asking them for ID and they're refusing or they don't have it, and then it's causing problems. And then the officer's like, "Yeah, well, you're illegal, so I'm gonna arrest you anyway." Then there's lawsuits, and then there's the civil suit, right?
Yeah.
And in the civil suit, we've seen cases, or in this panel, they were talking about cases they've had where, as part of the settlement of those civil suits, so first you got to get to a position of strength in the civil suit, like where you're going to win.
Right.
But then one of the terms of settlement is, yeah, you're going to pay us, attorney fee, or maybe they're like civil rights claims even, right?
Right. Right.
But part of the settlement, one of the terms is you're going to sign a law enforcement certification for a U visa for all of us. So there's ways that you can, in litigation, I don't want to say strong arm, but you can have it be part of the resolution of the matter that they have to sign one.
Right. Right.
And then not withdraw it, because that can always happen too.
Yeah. Yeah.
So.
Well, my computer here needs some juice. I'm gonna.
Oh, okay. I'll take your camera off then real quick. There we go. All right, America. Now you're looking at me. I see all the people looking at me. Let me know if you have any questions. Throw those in the comments. We've been talking a lot about U visas. I want to switch a little bit now to the topic of asylum. And I know Greg just loves asylum.
Always such an uphill battle, asylum.
It's always an uphill battle with asylum. Yeah. And 10 times an uphill battle in the last, over the last 5 years.
Yeah, definitely.
It's just a tough break after tough break when it came to that. So there have been a couple large changes recently regarding that. And apparently the Department of Homeland Security and the Attorney General's office are following, a recent executive order by President Biden to review regulations and come up with proposed regulations so that there's more clarity. Oh, I just locked. So that there's more clarity when it comes to asylum and who can apply, who qualifies, what are the procedures, and how to do it. So let's take a look here. Let me get Greg back.
All right, I got my computer back plugged in here, charging.
Oh, there we go. Okay, he's back. All right. So in fact, why don't we? No, I don't want to look it up. I just want to talk about it. It's so much fun. The first one we know is called Matter of AB.
The first one. Yeah, so Matter of AB was basically just the death to a lot of asylum claims. And it basically did is it.
Hold on, Greg. I can't tell if you're coming through on here yet. Let me add you again.
Right.
Oh.
Okay.
No, on my view, it shows you locking up.
I can.
Do you have the link still?
Yeah.
Did I send you it?
Like,
yeah. Try rejoining from there. Okay, so while Greg's reconnecting, I'll sort of walk us a little bit through Matter of AB. All right, so you know what? And all of a sudden, my mind's drawing a blank. I guess I need Greg here to help me with it.
All right, let's see if this works. No, I don't even see your screen.
Yeah, okay, you're gone from the system now. Try logging in again.
Okay.
All right, so let's take a look at, may as well pull it open. Well, Greg's reconnecting. I'll actually open these decisions because they are fun. Let's see. It would be under for June 16th. Here we go. Here's the precedence. Here's the decision vacating the matter of AB and AB2. And there's a decision vacating the matter of LEA. I can open these on my other screen here, and I can actually see it. There we go. Okay, and I love it when you can read a decision. Let's add Greg back here.
All right. Yes, it's saying having trouble connecting. Ding.
Oh, there we go. Oh, you know what? Can you plug right into? Let's see. See if you can put that into your device.
Adapter. That's right.
All right.
I'm gonna take me off.
Don't leave us. We're starting again now. Greg's plugging into the Ethernet. He's going to be ready to go. I'm going to start us off with the matter of AB. So let's talk about the Attorney General. The Attorney General of the United States. There we go. I fixed it right away. The Attorney General of the United States has the authority immediately to take any immigration case that's gone through immigration court proceedings, and he can refer it to himself, and he can change the outcome. So when Donald Trump was president, Jeff Sessions was the first Attorney General to do this in that administration, and he took a case called Matter of AB, and he said, this is totally wrong. I'm going to totally change it. And this was a case where there we go. Yeah, this was the case where there was something called a particular social group, and that was El Salvadoran women who are unable to leave their domestic relationships where they have children in common with their partners. So in an asylum case, you have to prove that you are being persecuted because of your race, religion, nationality, political opinion, or because of membership in a particular social group. What's a social group? What social groups are allowed? There's no definitive list.
Mm-hmm.
You have to sort of make them up as you go.
Right.
I guess we could say, or formulate them as you go. And they can't be overbroad. They can't be, well, they have to be what's called socially visible. So society as a whole perceives these type of people as a group. And so this was one of them, El Salvadoran women who cannot leave their domestic relationships where they have children in common with their partners. So we're talking about just those women in El Salvador. Not all women in El Salvador in this particular group, just those ones. And Jeff Sessions said, no, I don't think that's right. In fact, that is no longer eligible for protection. And at the same time, he overruled a case called ARCG, which said something similar to that, where women who were victims of domestic violence, I think it was Honduran women who were victims of domestic violence and can't escape it, that being a member of that social group would qualify you for asylum. So in one fell swoop, he ended those things. And, you know, we've had clients who did benefit from those cases before those sessions, but there's been like a lull in people being able to be approved based on that because of it. So now, so Attorney General Merrick Garland has referred that same case to himself. And think about it, you know, when we're talking about, Greg, we're talking about these cases.
Yeah.
It's not like Chevron deference where you've got some nameless company, well, not nameless, but faceless company.
Right, right.
They're like, okay, the government's going to defer to something.
Yeah.
No, we got real people.
Yeah.
So whoever was the client whose initials are AB, in matter of AB.
This was a real person.
It was a real person.
With a real case.
So in 2017,
Yeah.
when he took that case and said, no, we're going to undo it, that person went from having asylum
Right.
to not having asylum.
Mm-hmm.
And you only need asylum for a year until you can get your green card, right? But then you got to wait for that to be approved. So it could be another year after that. So you're dealing with someone who never got a chance to get their green card probably, and has been out of luck until 2 days ago. Or was it yesterday? Man, this week's been like a
Yes, I think it was yesterday.
Yeah.
And I have no idea who this
Whoops, sorry, I took you out.
Okay.
You're back in.
And again, as you said, we have no idea who AB is, but this person could already be outside the U.S. by now.
They may have been removed, right?
Exactly. Yeah.
Anyway, it's a good day for them.
Yeah, hopefully, if they're still here, they can benefit.
Well, they would still be able to benefit because they can get their attorney can get them paroled back into the country,
right,
to now have their asylum
have the option.
benefit. And I don't know, do you think they would make them wait another year from this being reversed again to apply for a green card, or could they apply right away now that more than a year has gone by? It would only be fair to let them apply now.
Well, hopefully they don't remand the case back to the immigration judge, from the BIA, because that would add how many months?
Yeah. Well, I think when the Attorney General does this, I mean, it's just
it takes immediate effect.
There's no BIA remanding anything.
Yeah.
It's done.
Mm-hmm.
So, I haven't seen on any of the attorney groups that we're part of, but I know because when it happened, somebody posted and said something like, "All right, Attorney General Jeff Sessions today decided to take out his vendetta against my client."
Mm-hmm.
And it was it's like in our circle of peers,
right?
One of us was not you or me, but
right.
One of us guys or gals,
right?
Immigration attorneys were dealing with that. So, anyways, that's undone. So, what it looks like what they're doing here now, and here's some fun about legal citations, because these cases are resolved, and then the Attorney General refers it to himself and undoes it. They start adding Roman numerals at the end of the case. So you can see here it talks about matter of AB parentheses 1, Roman numeral 1. So that was the original case. And then there's AB 2, which is where Jeff Sessions took it, reversed it, and then that was version 2. And now 3 is the current version of it. And again, one of the reasons they say they're doing this is because there's this regulatory process that's going to be taking place.
Yep.
And this case, I love how they were talking about it here. What does he say, for example? Having done so, he vacated the board's decision, blah, 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 subsequent board decision, blah, blah, blah. It just talks about all the different kind of confusion that's been caused by the decision itself. Here we go. Additionally, other portions of AB 1 have spawned confusion among courts. For example, the Court of Appeals have disagreed about whether AB 1 changed the unable or unwilling standard the board has long applied to determine, et cetera, et cetera, et cetera. So they list case after case after case where you've got like conflicting and confusing decisions.
Mm-hmm.
And as an attorney who practices in this area, they're exactly right. I mean, how can you sit down with a client and say, "Look, I got you. You're hiring the right person. I know exactly I know how this case is going to play out.
Yeah.
I know how we're going to win this.
Yeah.
I know what we're going to do." Can't, because at any step, something might change, or they take just a bizarre interpretation of what already happened. So
and you suddenly have to go back to the client and say, "Hey, we had a strong case, but now we don't."
Exactly. Yeah. Law changed. Sorry. Yeah, we had to even write that into our retainer agreements. Like, hey, we can't account for unforeseen changes in the law.
Right.
You have to make clients aware of that right on. So that was a matter of AB. So that was more about the domestic violence cases, the El Salvadoran women who are unable to leave their domestic relationships where they have children in common with their partners. And like we were talking before we started, I had one of the asylum cases that we won in immigration court was with a woman who could not get away from her husband.
Mm-hmm.
And she's like, "I want a divorce." And he's like, "I'm not going to give you a divorce." And then, he would beat her up, and she would go to the police, and the police there are not like the police here. And I think this is hard for a lot of Americans to understand.
Mm-hmm.
Because the police there said, "You're fine. Just go, look, he's drunk. Just make him his favorite meal. Be nice to him. It's going to work out. It'll be fine." They didn't investigate. They didn't arrest this guy. They didn't put him in jail. He never faced justice for burning her with an iron, with cigarettes, for stomping on her knees and breaking them, breaking her finger, all of these horrible things.
Right.
She's scarred on, right?
Mm-hmm.
well, once again, anyway, these people, they can qualify for asylum. So let's move on to the other one, matter of LEA. Now, do you have a good graph of, I shouldn't be asking this to you in public, but
Well, that was regarding family as a PSG, right? That was the original LEA. Sort of got rid of family. And again, the different courts of appeals have come down differently on this one. But one particular social group you can argue is family. So family member of a particular individual. So maybe you had a family member who was targeted by a gang or some criminal organization for a particular reason. And now that organization is going after that entire family. And you happen to be a member of that family. Now, maybe you yourself were not physically harmed, but there was somebody else in your family that was, and you have reason to believe that you're going to be next. And so the way that you would, formulate that particular social group is family member of so-and-so. And, that's a perfectly legitimate particular social group. With matter of LEA, they basically said, well, we're not really a fan of this. And I know after LEA, there was...
Well, that's LEA parentheses 2, right? Where Attorney General, I don't know if it was Jeff Sessions or Bill Barr at the time, who said, yeah, we're not going to go with those anymore. Because LEA was the case that we cited where it said, like, the family, the nuclear family, is the quintessential social group.
Right. Yeah.
It's the fundamental social group of society, right?
So LEA 2 then, actually modified LEA 1, and I guess now we're at back to square one in the sense that now family is a prototypical particular social group.
Yeah. So that sort of goes back to normal. Now, in one of these cases, was it this one here?
Again, with these cases, it's so hard to keep track because every 6 months there's this and then this, and it's just changing back and forth, and it's just challenging to remember case names sometimes.
The family social group is really important too, because a lot of the either the crimes that occur like in the Northern Triangle, they really do have like a family aspect to them.
Right.
Where so-and-so borrowed money and they didn't pay it back, and then they got killed, or they killed one of the family members, and that the threat was like, you're next if you don't pay up.
Yeah.
And I mean, we had one client who cousins and stuff like that were getting killed, and they all lived on the same street, and it's a close-knit community, but everybody sort of knows who's related to who, and if they don't get what they want, then they start taking it out on other family members. So there's that aspect. And one thing that we had run into, well, especially after the matter of LEA was LEA 2, where they revoked it, we'd be like, look, they were physically beat up, and they were told, you're next. You and your family are next if you don't do this. I mean, how do you say you're not being targeted because of that? And then, what the judge had to say is, well, I got to follow the law, and Attorney General Jeff Sessions says the law, that doesn't count, even if otherwise it would. So that was a good one. It's fun to see 2 cases come through like that, where both of them were names I recognized.
Right.
One because he was terrible, and one because I had actually cited to it, and then the later one was terrible.
I'm trying to think what decision should be next. I'm trying to think what other, decisions we saw from the Attorney General or the BIA in the last 3 years.
What am I thinking of AB as well, where they were talking about, because I read a case yesterday, and it talked about private criminal activity.
there was some dicta in AB.
That was an AB?
I believe it was an AB.
All right, let's find it.
Basically, he said,
there we go.
Generally speaking, victims of private
claims by aliens pertaining to domestic violence or gang violence perpetrated by non-government actors will not qualify for asylum. That broad, this is the decision that came out. It says That broad language could be read to create a strong presumption against asylum claims based on private conduct. As a result, AB 1 threatens to create confusion and discourage careful case-by-case adjudication of asylum claims, which is exactly what it did. It did exactly that. Now, and that's why every single gang violence related asylum case I've handled at the trial level, at the closing, the judge will point out, well, we're in the Sixth Circuit. We've got these cases that say this. That's not very helpful. Counsel, do you have anything that contradicts that? I say, I know that the case law here isn't good on general, gang violence, if that's the only thing. But also, those cases, we're talking about that particular case with those particular facts, with those particular pieces of evidence in the record. And there's a lot of people who do their own asylum case, right?
Right.
And there's a lot of, I'm sure there's attorneys out there who maybe don't prepare cases as well as they should. So maybe they don't have the physical evidence as an exhibit in the case that maybe could have swayed the judge the other way. Or could have shown that they in fact do meet criteria.
Right.
And I don't want, and we shouldn't assume, just like this case here is saying, we shouldn't assume that all cases are bad just because that one may have been poorly documented. So I point that out very specifically each time to the judge. I'm asking you to review the facts of this case. Look at our documentation. We have 37 exhibits to stack this high of all the country conditions and all the evidence of what happened here and all the reasons that actually this is a good social group. And for him, he's in danger of that, all the things that qualify you for asylum.
Right, because in every case you have to show the particular social group, and the judge has to go through that analysis every time. And as the applicant, you have to show a nexus to that particular social group. So it is this individualized assessment every single time.
It has to be. And the BIA doesn't like it, and the immigration courts don't like it because they've got so much work to do. And I'll be honest, there's many times where I've read the decision from the court, from the trial court, or is saying for the BIA, and it's like, and I just think to myself, like, okay, even if you were going to rule that way, you're not mentioning any of the evidence that we brought. You're not mentioning any of the points that we made in favor of granting asylum for this person. And there's some of those documents and orders and whatnot that look and feel like they're templated. So a lot of it's, judge makes the decision, we're going to go this way, and you got to wonder if they have time or the resources or.
Well, I mean, when you say that lack of time, that reminds me of this new ICE memo regarding different priorities, basically kind of a return to what we saw in the Obama administration with prosecutorial discretion.
That's right. There was this ICE memo as well. Let's talk about that. I didn't read it myself. I just assumed, okay, we're back to being somewhat normal again.
Well, it was similar to that. I think it was the 2014 memo with Obama, but this one is interesting where it sort of mentions the fact that administrative closure is not available everywhere in the U.S. Some circuits, have ruled differently, and so with this ICE memo, I think it's basically saying the ICE attorneys have discretion to just dismiss the case rather than administratively closing it, which is good in the sense that...
So actually terminate the case.
Right, which is good in the sense that your case is over, but for a lot of people, you want to get your work permit, and you can only have a work permit when you have an application pending. So if your case gets terminated, more than likely, you're going to lose that work permit as well. So it'll be interesting to see what happens because there's nothing to stop an applicant from filing affirmatively their asylum application with USCIS, getting a work permit that way. But, if that gets denied, well, then they're going to end up back in front of the immigration judge. So, I mean, strategically, I don't know. I don't know which way people are going to go.
I Googled that memo here because I hadn't taken a look at it. And I stumbled across this other memo that came out a few days ago by Gene King, the acting director of the EOIR. Yeah, this is the director, and it's talking about that memo, and it says, "Hey, there's this memo came out by DHS, so ICE is going to be asking to terminate, dismiss, et cetera, et cetera." And so I'm just reading here, like, what are some of the things that EOIR, the immigration court itself, so those judges, what are they going to be doing with this? And their memo is like, "Hey, your role is to resolve the questions before it in a timely, impartial, and consistent manner."
Mm-hmm.
Yeah, like that happens. It takes very long. Okay, 1.3 million combined cases pending before the immigration courts and the BIA. That's a record high. Miranda, EOIR's adjudicators should use adjudicated resources to resolve questions before them in cases that remain. Okay, so they're telling the judges to inquire, hey, is this a removal priority for you guys?
So it's sort of, I guess, shifting the burden from before where, the respondent would have to confront ICE and say, hey, I got this packet of all the equities. But now it looks like it shifts to the judge to affirmatively make that question of the respondent.
Yeah, and I've seen before times,
right,
before Trump,
the
judges would do that. They would say, "Hey, is this a priority for removal for you guys?"
Yeah,
and they would be like, "Maybe, maybe not," but that would give us an easy continuance.
Right.
So instead of having a hearing that day, the judge might say, "All right, well, I'm just going to continue it for another 6 months. You guys figure it out and let me know." And it looks like they're returning to that, and then even the direction of the EOIR, from the immigration judge's perspective, is that. Yeah, or where permitted by case law, agreed to administrative closure. It's still permitted in Michigan, right?
There was a recent case, the Sixth Circuit case. I'm drawing a blank on the name that I think did restore that ability.
Did restore administrative closure?
Right, because I used to live in the Fourth Circuit where that ability was restored a few years ago. But I believe that there was a Sixth Circuit case.
They said one of the options is stipulating to eligibility for relief. That used to never be allowed. You would have to go through a hearing, even if the other ICE officer was like, "Yeah, we think he's eligible." We still have to do the hearing. I wonder if they're going to actually have to do the hearing on that, or if at a master you can say, "Look, kid has cancer. That's the extreme hardship. Do you guys stipulate to eligibility?" And if they say yes, then the judge has entered order. That would be pretty sweet.
Yeah, that would save
shortcutting individual hearing and
save a lot of time.
Saves a day and a half or 2 days for the court.
Right.
Yeah. Let's see what else. Stipulating eligibility and close. They should ask the respondent and counsel for their position on the matters and take it into account before taking any action. They say use all docketing tools available to you to resolve these things. There's a couple more paragraphs here. Let's see. Board of Immigration Appeals. They should be prepared to review motions from DHS regarding prosecutorial discretion. Oh, so it could, at the BIA level, if it's pending appeal, ICE could file a motion. What would you call it? For miscellaneous relief, I guess.
Yeah.
Saying, hey, we've decided to exercise prosecutorial discretion. Just either remand it to the immigration court trial level or just, could they, maybe the BIA would terminate the case if they asked in the motion. Yeah, you could file a motion to terminate it with the BIA and say we've exercised prosecutorial discretion. That could work.
Or I guess the BIA could just admin close it there.
On their end?
Yeah.
Let's see here. In addition, appellate immigration judges may solicit supplemental briefing from the parties regarding whether it remains a removal priority for ICE or whether the parties intend to seek or exercise some form of prosecutorial discretion. Yeah, so sua sponte,
right?
The court can say, ICE, you gonna drop this? Okay. The board, there's a 8 CFR 1003.1 E9. The board may rule in the exercise of its discretion on any issue, argument, or claim not raised by the parties, and the board may solicit supplemental briefing from the parties on the issues to be considered before rendering a decision. I'm trying to think if I knew that. Did I know you can raise any issue on appeal? And in their discretion, they could say, yeah, we're going to listen to that argument now.
I didn't think that was the case.
I'm not sure I knew that was the case either.
That's news to
Let's read it
me.
again. The board may rule in the exercise of its discretion, ... comma, on any issue, argument, or claim not raised by the parties. And the board may solicit supplemental briefing from the parties on the issues to be considered before rendering a decision. Well, hot diggity dog.
That reminds me, because I was trying to think of a case that we saw that should be overturned. Matter of HOB. It was a BAA or it was an attorney general case, and it said that you had to formulate your PSG at the immigration court level. You couldn't introduce a new argument at the Board of Immigration Appeals. And so I think a lot of immigration judges took that to mean that you need to formulate on the record in a brief all of the PSGs that you're going to argue. Because I know after that case, a lot of judges said, I need a brief on the PSG. You can't raise it at the individual hearing. I need to see it, within 60 or 90 days. I think that was a matter of HOB. So it'd be great if that was vacated.
Yeah, because all of a sudden the judges did say that they want the written PSG submitted before the hearing.
Which was hard because, okay, we're at the master hearing, but 2 years from now, who knows what's
going to be a legitimate.
Yeah, I'm going to have to rewrite my brief.
Oh, yeah. Oh, yeah, because they were asking for it at the master calendar hearing too, right?
Yeah.
They would say, if you don't have it, we'll pretermit it.
Right.
Which just means they'll dismiss it out of hand.
Yeah.
Without going any further. Well, that is pretty interesting. All right, so ICE's priorities memo. When was that one released? I'm looking here, and I see the Department of Justice one. Let me see if they refer to it here. That wasn't from as far back as April, was it?
Well, there was one a few days ago, but then there was one, I thought it was like May, but I guess it was April. There was one that wasn't as clear about actually closing the cases out.
There's one May 27.
Okay.
There's one at February 18th. Is there another footnote here, maybe? April 19th. April 19th. Oh, look. Here's a fun fact for if any attorneys are listening. Administrative closure. This is in a footnote of this EOIR memo. Make this bigger. Scroll down. Let's see. Can I share? I think I can. Oh, I got to click, let's see, share screen. This may cause everything to crash. Look at that. You can see it there.
Wow.
All right. And so, how big can we make this? All right. Administrative closure is currently permitted in the 3rd, 4th, and 7th circuits. Citations is currently permitted in the 6th Circuit, but only to allow respondents to apply with USCIS for provisional unlawful presence waivers. Okay, so that's currently available.
Right.
Admin closure can still happen there if they'll allow it, if ICE attorney goes along with it, right? And then here's the citation from that. Yeah, look. That was as recent as June 4th, 2021.
Yeah, I knew that was very recent.
13 days ago. Okay, I feel less bad about knowing that one because it was just a few days ago. Administrative closure not currently permitted in the other circuits. Okay, so there's a lot of circuits, right? So 1, 2, 5, 8, 9, 10, 11, and DC.
Yeah.
Because of this guy here, matter of Castro Tum. Why don't they just reverse that one?
That's a good question.
Refer it to yourself and get rid of matter of Castro Tum.
Right.
That will completely fix the administrative closure thing for sure.
Well, again, speaking of cases with actual people behind them, Castro Tum was an actual person who if I recall correctly, he never received a hearing notice of his case. So I wonder if he ever, even is aware that he's a celebrity, right? Because that was the one I think he didn't receive notice, and then the judge admin closed the case. So presumably he doesn't have notice that there's even a case named after him.
I wonder if he's ever been found.
Yeah, because he
This would
didn't
be
have a
a-
lawyer.
This would be like a good documentary.
Right.
Let's see here. Well, he must know who he is because it's not using an abbreviation.
Well, because it wasn't an asylum claim. I think that's why.
Oh.
Yeah, because
Oh,
only
yeah,
the
yeah,
asylum
yeah,
cases
yeah.
where they have just the initials. So
Let's see here. Who is Matter of Castro Tomb? There's a picture of him here. Matter of Castro Tomb, LatinoUSA.org. Yeah, in 2014, an immigration judge had closed his case using administrative closure, which spared him for a time from being deported. Then in 2018, Roland's story collided with another man, a Guatemalan immigrant named Reynaldo Castro Tomb. Okay, so that's Reynaldo then. This is interesting. Okay. Citizen company minor. Okay. He was in an unaccompanied. So Reynaldo Castro Tomb was an unaccompanied minor, sent to live with his brother-in-law in Pennsylvania. And whenever that happens, nobody updates their addresses. So they never get the hearing notice then, which looks like it happened here. Jeff Sessions took up Reynaldo's case and issued a decision that would prohibit judges from using admin closure, but it's threatening to unravel Roland's life. Okay. And this, oh, look, they've got an episode here with some people talking about that. That's pretty good. So, yeah, he knows he's a celebrity now. And not only that, oh, no, because we're saying they didn't reverse it, but they should reverse this case and let him actually have his case as an unaccompanied minor. He may be too late now. He may be too old.
And that's the thing. His case was never heard on the merits, so who knows what he would have
qualified
for. Who knows?
He didn't come in early enough to be for DACA, so he'd be out of luck with all that.
Right.
Man. Yeah, so that's fun. So we got some comments. Let's read a comment here. Let's see here. My father is a U.S. citizen now. He is in hospital. He is unable to reach embassy. Is there any possibility to convert B1 to family-based green card? Wait a minute.
I guess I don't know if that's.
He's in the hospital. He can't reach his embassy.
Well, he's already a U.S. citizen, so I guess the question would be for another family member.
OA 32, maybe he's the one asking. Can you convert a B1 to a family-based green card? Sometimes. That's one of those things, man, where we really got to sit down and go over it. Do you have a B1? Did you enter the U.S. on the B1? Was that the only last time that you entered the U.S.? Now, if your dad's in the hospital and can't go to the embassy, that's probably okay. He can still petition for you, but he has to stay alive until whoever we're getting a green card gets their green card. Because if he dies before then that petition, well, no, it doesn't automatically die with him anymore. It's going to depend on a number of factors whether that petition can go forward, even if it's passed away or not. So, OA32, reach out to Greg and I here at Betzold Law, betzoldlaw.com. That seems like a good idea for you. I think, let me see, can I respond to a comment? I don't know if I can respond. I'm just going to put our phone number here in the comments. And you give us a call there, schedule an appointment with us, and we'll get you squared away because, yeah, if your dad's a U.S. citizen and you want to be able to get a green card, easier to do it when he's alive. You at least have to start the process while he's alive. So I want you to understand that for sure. All right. Well, we've been up for an hour and 24 minutes. That's pretty good. So I'm actually closing in on time to start my next episode with one of our esteemed guests from Bella Legal Assistance. So, Greg, thanks for joining me today. Thanks for coming into the office for this. I know that takes effort to actually come into the office these days.
Well, thank you for having me.
Yeah, well, it was fun talking about this, and you reminded me of even more good news that I had forgotten about. It's like it came in a wave.
A lot has happened.
And It's a nice change for a while.
A welcome relief.
Yeah. All right. Again, here is our banner. Here's our website, visaforlease.com. I'm Attorney James Betzel. This is Attorney Gregory Vanderwood. Here's our phone number, like in the comments. And tell you what, you know where we're at. If we can help you, that's great. If you're other attorneys and you have questions about any of this federal litigation, this U-Visa stuff, hit us up. We'll talk to you. We do it a lot. We've got Facebook groups open for that very purpose where we can all collaborate and work to increase access to justice for attorneys and their clients. Bye-bye.